we looked at, okay, we moved onwards. It seems that, okay, after Order 13, Order 19, Order 14, we're still going on with the trial. So what else do we do? If we know, okay, for sure now we have to progress along. It cannot be ended early. So a few topics. The first one is security for cost. Now, what is on your course manual under this topic is just various interlocutory applications that can happen along the way. It does not necessarily go through Order 23 first, and then Order 24, and then Order 25. Some of these applications may be made at various stages. Okay, so from now on, it's more depending who makes what applications. Security for cost. Now, defendant's turn. Okay, defendant is getting sued. Here, the defendant is saying, I think I have a strong case to defend. I think the plaintiff's claim is not strong. And because I think I have a strong defense, you, the plaintiff, is putting me to inconvenience by making me defend this action. As such, I, the defendant, want to make sure you, the plaintiff, has money to pay my legal costs if you lose. That's the basis behind the security for cost application. Again, be sure you understand that this is a defendant's application. Okay, we've been looking at a lot of plaintiff's application, haven't we? Right? This time it's the defendant, okay, flexing the muscle. So a defendant can apply for an order requiring the plaintiff to give security for his legal costs. So it's all about money again. On the basis that the defendant has a strong defense and that the defendant is being put to the inconvenience and expense of defending the action. But the whole rationale is that the defendant is saying, I'm worried that if I win and you lose, your claim lose, you have no money to pay me, my legal costs. Okay, the defendant may not have a counterclaim, right? So if I were the defendant, even if I don't have a counterclaim, but, Yuko wants to sue me while I'm the defendant. I want to make sure Yuko, at the end of the day, even if I don't have a counterclaim against Yuko, I want to make sure that if her claims against me fail, the losing party pays, right? Losing party pays means if she didn't succeed in her claim, she will have to pay my costs. But I'm saying, in making this application, I'm saying, well, I doubt whether Yuko has money to pay my legal costs if she loses. Therefore, I'm making an application requiring Yuko, the plaintiff, to put money into court as security. So I know at the end of the day, at the end of the trial, I'll at least get my legal costs back. Guess what? Application by inter partes summons and supported by affirmation. We explained that very clearly, right? This is like an application, sort of the document for application. And this is evidence, right? Remember the difference? Affirmation is evidence for interlocutory applications. And witness statements are for trial. Very good. You're better than a lot of PCL students already. Okay? The hearing is before a master in chambers, like most cases of interlocutory applications. Normal practice is for defendant to first write to the plaintiff enclosing a draft bill, of course, with the estimated legal costs up to a certain stage of the proceedings. For example, it can be up to the discovery stage, or it can be up to the trial. Okay, up to and before the trial, or even including the trial. Okay, so it's just like a demand letter, but it's only for this application. Hey, I have doubts, and you're not that you won't be able to pay my costs. I am going to ask you for security for costs to pay into the court. Remember, security is normally not to the other party. It's only payment into court. Okay? It's like if you purchase and sell property, right? Sometimes you have a firm, solicitor's firm, or independent party being a stakeholder to hold the money, right? 即係有個中間人 hold 住啲錢。 Okay, in this case, in most of the cases for security, for costs, or other security during the legal civil procedure, is the court holding the money for you. So normal practice is to write a letter to the other side first. So it's, again, who's writing the letter? Who's making the application again? Defendant. Okay? Defendant. Okay? Defendant is writing. So always get your parties clear who's making an application against who. Defendant's letter to the plaintiff, right? Saying, okay, pay money into court. That's I'm giving you an estimation. So what this is, well, estimated legal cost, but what's this draft bill? Item by item. Okay, so let's say you estimate there will be cost for involved in, well, the pleading stage, right? Drafting as that is defendant. So it's drafting the defense, and then preparing the witness statements. If you expect there is a certain expert evidence, things like that, item by item. Okay, so item by item. So that's why you have draft bill, like a table, itemized cost, items and cost. Okay. If the plaintiff refuses to provide the security as requested, then the defendant may apply to the court for an order. Up to the defendant to provide to the court or to show the court sufficient information to allow the court to decide on the quantum, which is the amount, right? Let's say the defendant is saying, yes, up to the stage of discovery, or up to the stage just before the trial, I think I'm going to incur $500,000. Okay, I itemized it, and the total comes up to $500,000. I write a letter to the plaintiff. Plaintiff refuses, so I go to court for an application. So when I have the application, of course, I show the draft bill of costs. I may also show any other material that supports my claim. Okay. Is it because sometimes if it's really around $500,000, you ask for $1 million, the court will ask you, what's this? This doesn't look very reasonable. The court can actually have a look and see the items and therefore decide what's the total quantum. If the defendant, being the applicant, in the absence of materials or information showing the amount or supporting the amount requested, no amount can be ordered as security. So if the burden of at least showing the prima facie evidence is on the defendant, right? Always on the applicant, who's initiating the application. If the defendant did not provide an itemized bill of costs, the itemized layout of item and amount, with adequate descriptions for each item, the judge may use his own experience and initiative and determine an appropriate amount, or the court can just dismiss. There should be master here, right? Is it master or judge in your menu? Yeah, it should. Yes, but here, I think in this, anyhow, I will just change it to. But on that page, perhaps it's, yeah, anyway. I'll just say the court. So it cannot be wrong anyway, but it should be the master. Okay, so the court can, if no itemized bill of costs, the court can, or the master can, use his experience to determine or dismiss the application, because that's the burden of showing the materials is on the defendant. Right? If the defendant didn't show it or give it to the court, then the court can not bother to make the estimation and just dismiss it. The normal order, if it is granted, is for the court to order the plaintiff to pay a certain sum, a fixed sum, into court by a certain date. The proceedings are stayed, paused, up to the date of payment. Because why do we pause the proceedings? Who is it punishing? Well, just remember, this application is by the defendant against the plaintiff. So the plaintiff's claim or the progress of the claim would be stayed if the plaintiff is ordered to pay but did not. Do you get it? Right? Again, if the court makes the order for security for cost, the plaintiff has to put money into court. If the plaintiff doesn't, the plaintiff's claim would be stayed. Okay, therefore, not good for the plaintiff. The defendant may also apply to the court for the action to be dismissed if the plaintiff continues to fail to comply. The court has unfettered discretion on whether to make the order of security for cost and the amount, the quantum. Now, it's not frequent that the court makes such an order. One of the main reasons the court would make such an order, and we sometimes, in practice, in the industry call it like a stage one, okay, like a stage one requirement, is that the plaintiff is ordinarily resident out of jurisdiction. Meaning, if it's a natural person, he or she doesn't live here in Hong Kong, right? So plaintiff order, it means just that. Okay, it's not about citizenship, it's not about having a Hong Kong PR, permanent ID card. That doesn't show by itself that the plaintiff ordinarily resides in Hong Kong. So you can get a permanent Hong Kong ID but live elsewhere, right? In this year or next year or for a few years, right? It doesn't prove that you are ordinarily resident in Hong Kong. A foreign company may be held to be ordinarily resident in Hong Kong if its central management and control are in Hong Kong. So whether it's registered here or not is not conclusive. Okay, the court looks at the real factual situation. Or some other circumstances where the court will or is likely to make an order for security for cost. The plaintiff is a nominal plaintiff. Now, normally it means it's a shell company. Shell company with no assets, very rarely trades or do any business, just sitting there. So, 空殼公司. No assets to pay defendant's costs if defendant wins. Burden is on the defendant to demonstrate by credible evidence that there is reason to believe the plaintiff company would be unable to satisfy an order for cost. Other reasons may include there's an incorrect or lack of address for plaintiff on the originating process. Now, you looked at the sample writ, and on the first page, almost towards the bottom, sort of maybe the second last paragraph or so, it shows the plaintiff's address. Okay, so if on the writ or on the OS, originating summons, there's an incorrect or lack of address, or plaintiff has changed address with a view or in order to evade the consequences of litigation. Remember the example we saw, changing addresses 6 times, right, in order to avoid something or being caught. Otherwise, there's reason to believe that the plaintiff will be unable to pay the cost of the defendant when ordered to do so. So this is like a catch-all, the last bit, right? Any other reason why the plaintiff is believed to be unable to pay or not pay. Okay, so remember the whole rationale behind it is defendant wants to make sure he'll be paid the legal costs if the defendant wins. Okay, that's the whole rationale. So ultimately, at the end of the day, even if it's a nominal plaintiff, or even if the plaintiff normally resides out of Hong Kong, it's not really conclusive. Now, but, okay, again, in exam, we only expect you to know what's on the course manual, right? And including the PowerPoints. But in practice, this is almost only a stage 1 test. In practice, and even in legal sense, if the plaintiff, let's say Yuko is a natural person, right, not a company. So Yuko, even if she lives in Canada, ordinarily resident in Canada, out of Hong Kong, if she can show that the case, her claim, has a high probability of success, she may be able to persuade the court not to make the order. Okay, if the plaintiff can show a very high chance of success, but it says high, okay, not just reasonable prospect, high probability. Okay, we don't expect you to know the extra bit, but that's what happens. That's like the stage 2 scenario. Okay, so can you think of circumstances where, yes, Yuko lives in Canada, so ordinarily resident out of Hong Kong. So how can she show the court that she may have she can pay, and she will pay if she loses? What do you think she can show? If she lives overseas? No, we just said that even now. Look back at the rationale. It's like I don't know how to chase Yuko for money if she loses. Okay, I don't know how to chase. Well, what if she has fixed assets in Hong Kong? Right, we're going to learn later in another about 2 lectures away, enforcement of judgments. So if she has like real property in Hong Kong, perhaps that's okay, right? Because you don't normally sell a property that quickly. So real assets in Hong Kong, perhaps I can enforce judgments against those property. And that's one way to. But if she has, okay, let's say she has a permanent Hong Kong ID card, but she doesn't have real property. She has 2 bank accounts. Is that good enough, do you think? Are the bank accounts or balances in the bank accounts good enough? Not as, right? Because she can just withdraw the money anytime, right? It's too liquid. Whereas if I can show there's property, and she can show that she has real property in Hong Kong, and that she's lived here for a very long time, perhaps she still has family here, all that adds up. Plus, probably she would want to show that she has a high probability of success in her claim. Okay? Okay, reflection activity number 1. Upon the application of a defendant for security for costs, the court has an unfettered discretion. Unrestrained, right? You know it now. Unfettered just means not limited, unlimited discretion to grant or refuse to grant an order. The court will conduct a weighing exercise, so a balancing exercise. How do you think the following issues may affect the court's discretion? In other words, do you think that these factors affect the court's decision? Does the plaintiff has a bona fide claim? Would it affect the court's decision? Yes, for sure, right? We're saying the plaintiff's claim or strength of it. Number 2 is the application for security for costs being used to stifle a genuine claim of the plaintiff. In other words, is it my intention to make this application in order to be oppressive against Yuko? I know she doesn't have a lot of cash. If I make this application, perhaps she will succumb to pressure, financial pressure, and drop the claim. Do you think that's a factor the court will look into? Being used by the defendant to stifle a genuine claim of the plaintiff. In other words, the defendant's motive. Yes, the court doesn't like malice, right, so to speak, or that kind of intent to be oppressive. Number 3, does the order, if made, prevent the plaintiff from pursuing a claim due to impecuniosity? Okay, my 4th attempt. Impecunious, I can. Impecuniosity. Okay, so due to being poor. Okay, can I use a simpler word? Okay, yes or no? order, if granted, prevent plaintiff from continuing the claim due to being too poor? Do you think that's a factor the court will look into? It's sort of related to number 2, isn't it? Except that one is intention. This one is factually, would it stop a genuine claim due to the plaintiff being unable to pay the cash as security? So yes, 2 and 3 is like intention and factual, right? Yes, it would be injustice, right? Being oppressive, right? Those who are loaded with money would win anyway, right? Number 4, has there been an unreasonable delay in making the application? Well, it's very hard to say what is unreasonable delay, right? Because you can make the application at any stage. There's no stopping you making it just after the pleadings or beyond. Okay. Normally, people won't make it until the pleading stage close. Why do you think so? No, as in, people would at least wait until the pleadings have closed. Why do you think so? Look back at the rationale. Not quite. We are saying we are going to look at the relative. We can look into the relative merit of the case, right, between the plaintiff's case and the defendant's case. Well, if you haven't gone through the pleading stage, how can you tell? Right? So for that reason, normally at least after the pleadings stage has closed. So you can look at the relative merit so that you can tell the court, right? Number 5, does the defense appear to be? So I can't really give you a firm answer on number 4 because when it's delayed, right? You can almost make it at any stage, except probably it would be a bit weird if you just make it before trial, right? That would be very late stage in the whole litigation process. So if people make such an application, they would have made it earlier on. Number 5, does the defense appear to be a strong defense? Just like looking at the strength of or genuineness of the plaintiff's claim, the court will also look at whether the defense has a strong defense. Right? That's what the defendant is arguing. Right? The defendant has a strong defense. Okay? Any questions? Yes? Well, it depends what the court wants to do. If the court is lenient, kind, and generous, it may give an estimation, even though there's not sufficient information before it. Or else, if the court do things by a very strict sense, it can just dismiss the application because it's the defendant's responsibility to show the itemized bill of cost. Okay? So depending on whether the court is lenient. Yes, on the occasion, what we're saying is that if the defendant made the application but did not prepare those information, then it's up to the court which path to go. No, not in the strict sense, but it would be very weird if you make it very late. Because, well, let's say out of the time. No, but remember, it's very difficult because you cannot see the relative strength. How can it would be more difficult for the defendant to show why he says he has a strong defense, right? They might as well wait for it. And also another reason, if it's very, very early stage, well, it would have been an SOC, otherwise you don't know what the claim is. But let's say you haven't done the defense and the reply, perhaps it's harder to estimate the cost as well. You don't know whether you need expert evidence, you don't know how many witnesses you need, etc., etc. Too many unknowns, right? So let's say if this is the writ, when we have the writ, and this is the trial. Right, so let's say the pleading stage, okay, and then if you don't make the application, you wait until the trial. Because what is the effect? Remember what the effect is. If I made the application against UCO, say the effect of the order would be, if you don't pay that security into court, you can't continue to pursue the claim, right? And why would you want to do that so late, right? Both parties would have incurred a lot of costs. And if you only shortcut it there, that's a bit weird and quite unfair to her as well, right? Because, well, so you are saying you just stop me there, 臨門先嚟認我, right? Then it's quite unfair because I would have incurred a lot of costs and now you're stopping me from my claim, right? So I guess this is a little bit along that line, but there's strictly speaking no time limit. Although if it's at a very late stage, let's say just before trial, the court, I would say, is unlikely to grant it. Interim payment. Okay, flip the coin again. This is an application, again, interlocutory, by the plaintiff. If ever you get confused with the parties, just think about who can get payment. If it's a claim, and assuming no counterclaim, who gets payment? Plaintiff, right? If he wins. So here we are saying, let us get some first. The plaintiff is saying, let me get some of it first. The rationale, my case is a sure winner. Let me get some of the money first so I don't have to wait until so late. Okay, so advance or, advance would do it. An advance payment for the plaintiff on account of any damages, debt or sum. Interim payments, only money, right? Only money. Account of any damages, debt or other sum, excluding costs that a defendant may be held to pay if the plaintiff succeeds at trial. Now normally, if you're claiming for 3 million, interim payment will not be for 3 million. Otherwise that would have been like final judgment, right? So it's normally a reasonable proportion of the sum. Rationale, plaintiff's application to lessen the plaintiff's financial burden between the writ and the trial, or between at least the pleadings, okay, and just so that plaintiff doesn't have to wait until the end. Okay, between the commencement of action and the trial. Guess what? Application by. How do you make an application? Like most other interlocutory applications, you make the application by in what kind of summons? Inter partes. Okay, inter partes summons supported with, we can almost fall asleep on that. Okay, supported by affirmation. Hearing before, master in, yes, you can almost copy and paste. Okay, application may be made at any time after the writ has been served on the defendant and the time limit for acknowledging service has expired. Okay, before masters, in chambers, but can also be heard by a judge. Now, additional information. Most of these interlocutory applications, the hearing are before masters, right? In chambers, that's what we said. But occasionally, one of the parties or both of the parties may apply to be heard, for the application to be heard before a judge. Some of those rationale, this is only in practice. The rationale may be that they think the law is quite difficult, or they think that, okay, between Yuko and myself, well, whoever wins is whoever loses is going to appeal anyway, so we might as well go straight to the judge. That's the rationale. Okay. Now, pay attention here. Grounds for discretion to order interim payment. Where the defendant has admitted liability. So we know it's a winner, right? The plaintiff is the winner. The matter is only how much, the quantum, right? Where the defendant has admitted liability, or where the plaintiff has obtained judgment against the defendant with damages to be assessed. So what we're saying is, again, well, how do you obtain judgment with damages to be assessed? So you obtain judgment on liability. So can you see the first 2 points here? One says that the first one is defendant has admitted liability. The second one here is the court has found or has made a decision on liability, right? The second point. That's essentially what it is. So the first 2 points, liability is already final, right? Again, only a matter of how much, the quantum. Here, the third is to be argued, right? Where if the action proceeds to trial, the plaintiff would obtain judgment for substantial damages. This too is pretty much good ticks, right? On either of this, if you fit into one of these criteria, defendant admitted liability or the court has decided on liability, you're pretty safe, or the plaintiff is pretty safe to get the application. Here, it's up to the plaintiff to prove, right? This is where the parties have to argue for the application. Okay? No need for the plaintiff to show particular financial hardship, although it may help. So it's not a precondition for plaintiff, me, the personal injury victim, to show to the court, I don't have enough money to eat. But it is a factor that may help to persuade the court. Sun Jiangqiang, and Chen Takao, I think it is, and another. Plaintiff's application, plaintiff to prove. Okay. Normally, whichever, well, it's again given. If it's a defendant's application, like the security for cause, it's defendant's burden to prove. Interim payments, plaintiff's application, plaintiff has the burden to prove the defendant's liability through affidavit evidence. It's a high burden because this time, who is the money paid to? Interim payment. If the order is made, the money is going to be paid out to the plaintiff. So this time it's real money in a litigating party's hands. So you've got to be extremely careful, right? It would be disastrous if, in the end, the plaintiff actually doesn't win anything and yet money has been paid out, right? So therefore it is a very high burden. This time the money is not held by the court as a stakeholder. It's paid out to the plaintiff. The court will examine the merits of the plaintiff's claim in detail. And the last point there, the court must be virtually certain, pretty much sure, that the plaintiff will win at trial before such an order will be made. How can the defendant oppose? Technicality, no liability had been admitted or found by the court yet. Most likely is arguments on the merits. No, it's not. The plaintiff doesn't have a high chance to win. So on the merits, so the master, you shouldn't grant the order for interim payment because, see, the plaintiff's claim is not so strong. You can't be sure that he or she will win. Amount, let's say it's a $5 million claim. As the defendant, I'm the defendant, I'm the plaintiff, I'm seeking for interim payment for $3 million. I say it's only a reasonable proportion. But perhaps the other side, the defendant will argue, no, I think the quantum, if you win at all, is going to be only in the arena of $1.5 million. So your request for interim payment for $3 million is totally out of out of line, right? Totally unreasonable. So any other relevant factors. But mostly on the merits, on this too. Merits and quantum is the most often argued platform, right?
So it's Form 16 or 16C.
Well, in that case, if you are saying you do not contest the claim, but only on liability, or on quantum, then yes, because you can't turn back, remember? Yes. But if you use 16 or 16C, you're almost already agreeing on the quantum. So that's quite different as well, right? So normally you would only say liability is admitted. But if you use 16C, remember it already goes to the length of talking about payment terms, okay? In PI cases, personal injury cases, an interim payment may be ordered only if the defendant is insured, public authority, or has the means and resources to make the payment. Insured, because insurance company, we think they are very rich, okay? Public authority, probably likely to be able to pay, or else must show that they have the means and resources to make the payment. Impecunious defendants, poor defendants, or financially poor defendants are protected from interim payment orders in personal injury cases. The trial judge should not be told of any interim payment until the trial is over. The fact that an interim payment has been ordered should not be pleaded. Now remember, this application is heard before a master, right? It can be a judge also, but most likely master or a judge, but not the trial judge. Probably not the trial judge, right? Well, you may say, hang on, Vivian, I thought you only said WP communication is privileged and cannot be disclosed, or negotiation or settlement offers cannot be disclosed to the judge, trial judge, remember? So as not to prejudice the trial judge's impression of the case, right? The problem, the issue is prejudice. So because, what did we say? To get interim payment, we are saying this, right? In order for that master or that judge to grant an interim payment order, the court, meaning the master or the judge, was sure, or is sure, virtually certain, the plaintiff will win. So that's like an opinion, right? So we don't want the trial judge to know about this order, because it will make him think that, oh yes, there had been an interim payment order. Probably the plaintiff has got the upper hand, right? Or is more likely to win. Because see, someone else thought it would be virtually certain the plaintiff would win. Make sense? So as not to prejudice the trial judge. Reflection activity number 2. Obvious advantage for awarding an interim payment to a plaintiff is that he or she will receive early partial payment, rather than having to wait until the very end after the trial, or until damages are assessed. However, the court has to be certain that the plaintiff will succeed in his or her claim. Consider the following cases and advise clients on an application for interim payment. Oh my goodness. Okay.
Wall of text.
So we have a landlord. If the font is too small, you may want to look at your manual. Landlord-tenant. Landlord let his shop or premises to tenant, 2-year term. Okay, so it's a 2-year term, monthly rent of $20,000. The tenant took possession, meaning went into occupation of the shop premises, and intending to operate her business as a car mechanic. Soon after she started her business, the IO The incorporated owners of the building began substantial maintenance work around the building, erecting scaffolding outside the shop, etc. Greatly or adversely, right? Not a good effect. Adversely affecting the tenant's business. Tenant accused landlord of failing to tell tenant that there would be such maintenance work. Tenant refused to pay rent. Landlord, because the tenant didn't pay rent, landlord terminated the tenancy and commenced action against the tenant for possession, meaning recovering, taking back he wants to take back the premises, and for damages, probably the unpaid rent. Landlord would like to apply for interim payment. He's a wealthy person and told his solicitors that he had no knowledge of the maintenance work was going to take place. Tenant, the defendant, told her solicitors that she had told landlord of the nature of her business and she believed landlord did know about those maintenance work upcoming. Tenant said because of lack of business, she could not afford to make any payment of rent. Okay? Although rest assured she can pay your legal fees. So what do you think? Well, it's a landlord-tenancy dispute on a lease, fixed 2-year term, 20,000 per month. Well, interim payment, go back into the rationale. The plaintiff, being the landlord, wants to get some money first. Right? Wants to get some money first. The court has to be virtually certain that the landlord is going to win. Do you think it's a very clear case? Okay, you've got to look at it from different facets, right? We have rationale is to lessen financial burden, although landlord does not necessarily have to show impecuniosity. Okay, I succeeded. Okay, so is this satisfied? Has defendant admitted liability? Has the court ruled on liability? If the action proceed to trial, would plaintiff be likely to obtain judgment for substantial damages? Well, it depends what you say is substantial or not, right? But there's a fixed amount. You would say that probably the unpaid rent so far. So no need for landlord to show financial hardship, although it would have helped. But he's wealthy, isn't he? Virtually certain. Can we say it's virtually certain? What is the claim? The claim is for unpaid rent. The defense is about this maintenance work that the tenant is saying the landlord knew. Is it that clear cut? Is it that clear cut? What do you think? No. Can the court be virtually certain? Not really, right? It's far from it. Also, how about, is the defendant insured? Well, it's not a personal injury case, so we don't have to, I guess we don't have to think about it. But we don't have to think about this. Notice that it's only for PI cases. But the second main bullet point here, seems that the defendant is also in financial hardship as well. Right? So, likely or not? Don't think so. Right? So just a summary point on those. Grounds, well, here we can say that no liability admitted by defendant. Court has not ruled on liability. Okay. We are not sure. Well, we know the fixed sum, probably the unpaid rent. None of this seems to apply. Right? The court, I think it's far from certain about who's going to win the claim. Plaintiff is a wealthy person, not in financial hardship. The defendant is. So more likely than not, the order for interim payment unlikely to be granted. Okay, I would say. okay, on a totally different arena. Okay, anything uncertain about interim payment or security for cost? No? Okay. Now, how long is witness statement? Okay, good, we're still early. Oh no, very short only. Okay, let's go on.
Sorry, excuse me. Could you speak? Is there a way to make the mic a little louder?
It's too
It's
low.
a little
volume
bit.
is low?
It's a little bit quiet. Yeah.
Okay, sure.
It's just a bit. Yeah. Thank you.
No problem. Now, witness statements. Remember what witness statements are for. They are evidence, right? Witness statements are evidence for trial. You're correct, right? Written statements of the oral evidence that a party intends to give at trial. So it's like a transcript of what I intend to say at trial. Both parties must prepare and exchange witness statements before the trial is set down or fixed for hearing. Usually exchanged at an agreed date and time. The purpose is to disclose all intended evidence of a party. It is now the practice in civil trials for the witness statements to stand as examination in chief of a witness. Okay, point by point. Okay, you know what this means. I'm going to read it again. Exchange. Can you think of a reason why it is exchanged at the same time? Why don't we just file it whenever we want? As long as it's before trial.
See.
Yes, of course. The whole purpose of this is no surprise, no ambush again. Remember those underlying objectives. So, but why at the same time? Simon, right? Why would I'm the plaintiff, you're the defendant, why do we exchange witness statements at the same time? No matter how many, right? Let's say I have 3 witnesses, you have 2 witnesses, it's all in one go, one lot. Exchange. Why? Why at the same time? Say again? Licensing? Smooth operation, yes. Yes. Right? If I just say, okay, we should get the witness statements ready and file them and serve on each other. Simon made it filed and served his witness statements on me last Friday. I wait for another 2 weeks. I can counter his evidence or arguments in mine if I'm later, right? That's why they're usually exchanged. What if we've got more to say? Okay, this is again beyond your course manual. What if we've got more to say? What if I've got a typo? Now, just for your information, witness statements cannot be amended. Unlike pleadings. Pleadings can be amended, remember? Remember those 4 colors? Witness statements can't. The only thing you can do is do a supplemental witness statement, okay? To clarify matters or to supplement with further information and evidence. Okay? So cannot be amended. Now the practice in civil trials for witness statements to stand as examination in chief. So let's say it is a very substantive case with lots of evidence spanning over 30 years of the lifespan of a family or whatever, okay, whatever the reason is. Now, the purpose of preparing witness statements, now, let's say I am a witness. I told of the history of the family since the great-great-great-grandfather until now, so history, right? So if I stand in court and read it out, my witness statement, do I read out my witness statement? No, nowadays we don't. Because that document has been prepared, everybody has it, right? I have my own, I served on Simon and Mike my witness statements. So everybody's read it before the trial. The only thing we ask the witness to do is to adopt it. So, Simon and James. Okay, correct words. Okay, so James is a witness. So let's say I'm the, doesn't matter. You are the plaintiff's witness, I'm the plaintiff's counsel. When he gets into the witness box, what happens is, yes, please state your name. James, whoever. James, okay. Can you look at the document in front of you? Okay, please turn to the page 34 in the bundle. What do you see? Say, this is my witness statement. Okay, can you please turn another 5 pages? What do you see at the bottom? Do you see a signature at the bottom? Yes. Whose signature is it? Mine. Do you confirm that this is your witness statement? Do you see? He's very good being prompted, right? Do you confirm this is your witness statement? Yes. Do you confirm that the contents are true and accurate to the best of your knowledge? Yes. Do you now adopt this witness statement of yours as your evidence in chief? Yes. That's it. That's what we mean by adopting. In the court, that's what the witness will do. So you know that you may have heard of evidence in chief, which is the main evidence, right? I'm the plaintiff's representative, or legal representative, or counsel. He's the plaintiff's witness. Okay, so the same side do the evidence in chief. He will then be tended to the brutal cross-examination of the other side. Okay, that's cross-examination, and they will ask questions. And then I do a re-examination. Okay, but that's how evidence in chief is done nowadays. The court will not allow you to venture too far. A kind judge will allow a little bit of elaboration, but very, very few judges now do. If you have something to say, you better put it on your witness statement as your evidence in chief, right? Whatever you want to say on behalf or in support of the plaintiff. What if you say, no, this is not your witness statement? Well, then something must have done something very, very wrong along the line. Okay. Okay. Now, I haven't seen one yet, except in a movie or whatever. So, anyway. Okay, so I'll be sure you never be my witness. Okay, witness statements should contain all the relevant evidence that the witness is able to adduce. Of course, he can only tell what he knows, right? He shouldn't go and venture far and give his own opinion on things that are not within his expertise or not within his direct knowledge. A normal witness, that is, unless he's an expert witness, what we call an expert witness, he cannot give opinion. He can only tell facts. What he's seen, what he saw, what he knew, whether from personal experience or documents within his custody or control. Right? We'll talk about expert evidence later. Okay, detailed provisions concerning forms, contents, amendment. You can't have amendment. Okay, let me check that out. Translation and exchange of witness statements contained in RHC Order 38. As far as I know, you cannot do amendments, not to witness statements. Okay, contained in Order 38, Rule 2A. Rule 2, capital A, is all about witness statements. Witness in court. The witness is generally confined to the contents of his witness statement in court. He cannot just stand up, oh, but I have something more to say. Cannot. Witness statement must be, just like a pleading, must be verified by a statement of truth in accordance to Order 41, capital A. Okay. And the document is pretty similar to, like you've seen what a pleading looks like. So where it says statement of claim or where it says defense, it will just show witness statement, and then it would be the particular witness. Okay. Let's say, because remember, one party can have more than one witnesses, right? So it would just say witness statement of James witness statement of Simon, etc., right, or of Alice, and so on. As you see, we have, that's it. Reflection activity 3. Pursuant to rules of High Court, the court will order written statements of factual witnesses to be exchanged between the parties before the trial. These witness statements are now to be prepared at an earlier stage than had been in the case prior to the CJR, Civil Justice Reform. Discuss the advantages and disadvantages that the early preparation of such witness statements to the parties. So, good side. What's on the upside? Early preparation of witness statements. What's good? What are the advantages? I guess the same thing, no ambushes, no surprise. What else? Those CJR objectives. One of the objectives is to probably saving costs, probably more focused, because you know very much what the case is about, what evidence are available. You know what to explore if you need to. Probably again, relative strengths and weaknesses, so possibility of settlement if it's more one-sided or if nobody knows who is going to win, may have pressure to settle. What about the downside? Well, first of all, you can't ambush, right? If you want to be mean, you can't ambush, you can't surprise, right? It's good and bad. Because some people like to do surprise attacks, right? Some legal team may want to do that. It restricted your case, doesn't it? You can't, well, once you've got it on paper and reflect to others, you can't really change your mind on how to run your case. Just like your pleadings. Right? And when we have witness statements, although you may have seen some samples of them, in real witness, in practice, the witness statements also have a lot of exhibits. And that's how we disclose, apart from the list of documents, that's how we disclose evidence to the other side and also to the court. Okay, so if it's a contractual claim, you would have exhibited your contract, perhaps your correspondence between the parties about the terms, about the date, payments, inspection, proof of inspection, proof of payment, etc. Right? So all those would be attached as exhibits, referred to and attached as exhibits, as evidence. Okay. Can I push here? Okay, expert evidence, how many slides? Okay, short again. We'll finish expert evidence first. Expert evidence, remember I told you, normal factual witness can only give evidence on facts. Cannot give opinion. Your views are not important. We only want what you know as a fact. If we want opinion, that's what we get expert for. Okay? Expert evidence are opinion evidence provided by an expert in his particular area of expertise. The expert must be impartial and must be qualified as an expert in the area in which he is to give evidence. Now, can you think of some reason why we may need expert evidence? What are some areas that you think we can? Well, not law, right? Because law is what the legal team is for. What would be some of, or can you give some examples of expert evidence? PI case on injury. Yes, extent of injury, recovery, loss of movement, ability, etc., etc. Okay, permanent impairment kind of stuff. Apart from personal injuries, what else? Can be a lot of areas, right? What about valuation? Evaluation on land or property, valuation experts. What about leakage, water leakage? Some very common course of action, right? A very common course of action in every day in Hong Kong, because we live in multi-story buildings. Source of leakage, okay? You may need an expert on that. What about technical stuff, right? Was it bulldozers or was it something else? I can't remember, okay? Well, was like technical expertise. Was that up to specifications? Was the production of those bulldozers or projectors or whatever, are they up to the specifications required, right? So those would all be expert evidence or may require expert. An expert may only be called by consent of the parties or with leave of the court. Okay, if both parties agree, yes, we need expert in this area, we can't decide by ourselves. It requires opinion, an expert opinion, or with leave of the court. Provisions on the use of expert evidence and expert reports are contained in Rules of High Court, Order 38, Rules 35 to 44. Now, whenever you look at, just like any other areas in the Rules of High Court, Order 38 is all to do with the whole Order 38 is on evidence. So if you want to say witness statements, be sure you refer to Rule 2, capital A. Expert evidence, be sure to refer to specific rules rather than just say Order 38. Okay, if you can't remember anything, Order 38 is better than nothing, but it's not very specific. That's what I'm saying. Now, looking at the expert from the perspective of the expert, this is not very good. From the perspective of the expert, an expert witness has the duty to assist the court on the matters within his expertise. On the matters within his expertise. Okay, that's by Rule 35, capital A. The duty is first and foremost to assist the court and overrides, prevails, trumps. Okay, that duty to assist the court is higher than the obligation to the person instructing or paying the expert. Okay, so even though you're paid by one or both of the parties, the expert's duty is first owed to the court, because otherwise it would be unfair and unjust and prejudicial, right? The expert should be impartial and not act as an advocate. Okay, but they don't always obey that rule. Now, to say, what do you mean? So he's here to give evidence, right? So we are seeking his opinion, so why can't he argue? He cannot. To give you an example, you can, for example, let's say the water seepage, water leakage from the 20th floor down to the 19th floor of whatever building. The leakage or the expert, okay, the expert can, after testing, etc., he would have prepared an expert report, and in that, his opinion. He can give opinion. Let's say he collected the data. He can form an opinion based on that data. For example, on the source of the leakage, okay, where the water flowed. Is it really from the 20th floor down to the 19th floor, or is it from the external walls? Right, in Hong Kong, well, in law, there is no presumption that the water leakage comes from the floor above. You've got to actually proactively show the cause of the leakage before you can succeed in a claim. So the expert may say, yes, it is from that crack and this and that and that. However, what we mean by not advocate is he cannot go to the final step and say, is the fault or the defendant is liable. That's one sentence he cannot say. That's for the judge to decide. Okay? And that's what the whole case is about. So, for example, valuation. You may say, okay, the market price of a unit in Twin Moon of a bright view with that kind of size is about 5 million. Cannot go ahead and say, yes, I think that is quite, you cannot go on to talk about liability, is what I'm saying. Cannot go the final step and say, yes, that should be the final quantum or that should be the liability, right? Only on opinion within his expertise, which is on data. It may be because of data, it may be because of the information he has. Okay, he can form an opinion, but not say the final conclusion. An employee of one of the parties may also give expert evidence. That's under the case law of Tang Ping Choi and another, and Secretary for Transport. Well, if you think about it, would you like one of the party's employee to be an expert? Probably not, because you would argue that's not fair, right? It's probably biased. However, if it's one industry where it's very hard to find expert, you may. Of course, if the employee who went ahead and acted as an expert, giving opinion, is also supposed to be impartial. Okay, but it's up to the parties to argue, but they can. A party instructing the expert witness must provide him with a copy of the Code of Conduct. I'll show you the copy later. It basically tells the expert his duty to the court, that he has to be impartial, he has to say the truth, and so on. Okay, be honest like that. An expert report must be verified by a statement of truth under Order 41, capital A. In the report, the expert must make a declaration that he has read the Code of Conduct for expert witnesses and agrees to be bound by it, and that he understands his duty to the court and that he has complied with it and will continue to comply with it. So it's a continuing duty. Okay, so in a typical expert report, you will have a cover page, and then you would have most likely they would include a CV of the expert on his qualifications, on how many or what type of cases he's acted as an expert for, etc. And there will also be his signature or verification by the statement of truth. Okay, that's pretty standard. In practice, reflection activity number 4. In practice, if a party produces an expert report and calls the expert to give expert evidence, it is expected that the evidence will be in that party's favor. Pursuant to the civil justice reform, experts are reminded that they owe an overriding duty to the court and are to help the court on matters within their expertise. Discuss the practical implications of this. In other words, do you believe it? Yes and no. Okay, so you will see the situation that in reality, normally, let's say I have a case against James. Okay, so I may want to have my own expert, he may want to have his own expert. So likely we are each going to have an expert report, or else it's also very common nowadays to have what we call a single joint expert. So we, James and I, co-instruct, or co-engage, I should say, co-engage an expert that we both feel okay with. And that expert will produce what we call single joint expert report. Okay, SJE, yes, single joint expert report. Okay, so SJER. So that's that. However, any communication, that is very, you have to be very careful, because every time you communicate with that expert, both parties have to be in the know. So you can quietly go and say, Simon, I think this should be this way. So can you make sure you have it in your report? I cannot do that. Okay, so all communication must be open. Every time I communicate with Simon, I have to copy, let's say it's correspondence by letter, I have to copy James on it, right? And vice versa. Okay. Any other comments on this experience to share? Okay, so perhaps we can... Okay, so let's have a break now.